Millions worldwide use social media sites like Twitter and Facebook as an important communication tool. But as these social media sites become more ubiquitous, groups like terrorist organizations are also using them to spread their message and gain followers. So where do private companies draw the line regarding who can use these platforms?
According to research firm eMarketer, nearly 1 in 4 people in the world will use social media in 2013. So it's no surprise that groups deemed terrorist organizations by the U.S. government have started to join the conversation, eager to reach this rapidly growing audience.
Part of the reason for that is that those sites were vulnerable, but much of that has to do with they simply went to where the audience was and where their hoped-for recruits were, which is the hundreds of millions of people who use Facebook, who are on Twitter, who view YouTube videos regularly.
Zweig says that the presence of social media accounts that represent Hamas, Hezbollah, and al-Qaeda violate a U.S. law that bars providing material support to foreign terrorist organizations. After Zweig's organization flagged Hezbollah accounts in a 2012 report, Facebook banned the group, but Twitter allowed them to remain, as did YouTube, although it did remove particular videos.
But memory is for the enforcement of American law prohibiting foreign terrorist organizations from being granted services by any American company, including these social media networks.
Attorney Lee Rowland with the American Civil Liberties Union disagrees that the material support statute applies to speech on these social networks. The U.S. Constitution provides broad protection to speech that does not incite violence, she argues.
Congress passed the Material Support for Terrorism Act. That was passed in the 90s. And in the Patriot Act in 2001, that law was expanded to ban giving any advice or material support to any terrorist organization that's listed by the State Department. And the ACLU's position has been that that cannot be applied to companies like Twitter and Facebook consistently with the First Amendment simply for allowing otherwise lawful speech to appear on their platforms.
Rowland says that protection for violent speech should depend on whether or not it advocates specific criminal acts.
When that specificity is lacking, and we're really just talking about ideas, no matter how unpleasant or even violent those ideas, we always believe it's better to have that speech be made in the sunlight, because that gives us an opportunity to challenge it.
The balance between fostering an open exchange of ideas and preventing incitement of violence isn't an easy one. And with ready access to social media, anyone from a jihadi to a stay-at-home mom can spread messages online. It's increasingly becoming up to these private tech companies to decide who gets to share and how much. This is Quinn Bowman for JN1 in New York.